I'm Kirk Langefeld, one of the attorneys here at Hawbecker and Garver. Today I'm going to talk to you about the multi-board contract, paragraph 21, plat of survey, paragraph 22, damage to real estate or condemnation prior to closing, and paragraph 23, condition of the real estate and inspection. So let's get started with the survey. So the seller is required to provide the buyer with a survey that is dated not less than 6 months prior to the date of closing. Now, that can be negotiated. If you have a survey that's older than 6 months, that can often be used, but one that has to be approved by the title company and two that has to be approved by the buyer to do that. It's very common, but as it gets older, it gets less likely that we would want to use that. So what does the survey show us? Well, the survey shows us the boundaries of the actual lot that's being purchased. It also shows what is constructed on the land, any easements, and building setback lines. So the survey is going to show that out. It's going to show what's written into the title commitment so we know what we are actually buying. So what this also shows, it can also show any encroachments that happen. Is the garage over onto the easement? Is the fence outside of the lines? Is the patio into any easement? These are all important things to know, because what they do, or what the effect of all this is that it affects the title insurance that the buyer is getting at closing. So the title company insures what the buyer is buying, and what part of that is they might be accepting from insurance. Well, we're not going to insure over a risk of loss for something that is an encroachment. If your house goes on to the other property, well, that's going to be a large issue that we need to know about, and maybe the title company insured and maybe they cannot. It would be something that's important to know prior to when you close. That's why these surveys are so important. What title companies won't insure is they won't insure what's called an adverse encroachment, which means somebody's property or something that's been constructed is actually going onto the property that you are purchasing. That's an immediate title claim. So the title company can't say, yes, we will provide insurance over that, because they are guaranteeing that they would be in litigation immediately, because why wouldn't a buyer take advantage of that insurance as soon as they could? So these surveys are so important, and there's so much that can be discussed on every specific survey, but that is just the basics of what we're looking at and what we want to see when we have the survey and what the agreement is between the buyer and the seller. Now, what if the property is damaged prior to the closing? So the important thing to know is that if there is damage, the buyer has the option of either terminating the contract and getting their earnest money back, or they can accept the real estate as damaged or destroyed, together with any proceeds from a condemnation award or an insurance payment. So if, let's say, the garage is destroyed prior to closing and there's an insurance claim to rebuild a garage, well, the buyer could say, okay, we'll accept that and we'll take the proceeds from the insurance. It's not very practical to do things that way, but in theory, that's the way it could be done. Now they might say, well, the garage has been destroyed. We don't want anything to do with it. We're going to cancel the contract. And that's absolutely the buyer's right to cancel the contract, move on to another property, get their earnest money back. One thing it does call out, the Uniform Vendor and Purchaser Risk Act. And what that act states is that innocent losses occurring during the contract period are allocated to the vendor, in this case, the seller. So other than as modified, which means in this case, the seller is going to be responsible if there's any damage. The seller is supposed to provide the property in the condition that it was at the time of contracting. And if they don't, the buyer has these options, which is really the basis of walkthrough issues and anything like that. And so moving on then to the condition of the real estate and inspection under paragraph 23, this is where the buyer has their opportunity to do a walkthrough prior to closing, because what they need to do is guarantee a few things or confirm a few things prior to closing. One, the property needs to be in broom-clean condition. Now, broom-clean condition is a little bit of a loose term, but I think we can all agree what that would be. It's swept, it's not mopped. Now it needs to be clean, everything removed from the property and swept up. And if it's not, there could be potential issues. But that is the basis for what it means for a seller to be out of the property and providing it in the proper condition. Now, what if something is not operational? Well, the contract says the property is supposed to be in the same condition as it was at the time as the date of acceptance, normal wear and tear accepted. And so that is where these negotiations come in. If the refrigerator is not working, if the air conditioning is not working, if the floor has been badly scratched, we often see that comes up as part of the move, and the walls are damaged. In that case, the seller is going to be responsible for that, and that could require a negotiation between the parties at or prior to closing. So it's always nice to have that walkthrough a little bit before closing, so any of these issues can be avoided. I hope this has been a helpful primer to these sections of the 8.0 contract. Feel free to reach out to me with any questions. Thank you for watching.